When I have a client that tells me a problem is impossible, it'll be the one time I deviate from the customer is always right. I don't think and I don't believe in impossible problems.
I'm George Whipple, one-on-one with Jonathan Brenner. Jonathan, welcome.
Good to be with you, George.
Talk to me a little bit about practicing law in California, one of the most challenging jurisdictions for employers in the country.
I didn't start in the practice as an employment lawyer. I started as a litigator with an emphasis in toxic tort litigation. And bottom line is, even though they're made of them, I found people to be much more interesting a subject for practice than chemicals. I must tell you, George, it's the only thing I would do in the practice is employment law first and employment law in California. Californians take their rights seriously, so it's a dynamic and very broad-based place for legal regulation and enforcement.
You know, one of the things that always struck me about you and your practice is that you say you're not advising clients, you're partnering with clients. Now, what do you mean by that, and how does that actually play out in real life?
Practicing in a way that delivers that kind of collaboration and partnering with clients is more than just being encyclopedic as to what the law actually is. It means really taking the time and giving the attention to understanding what your client's objectives are, what the practical aspects of their problem solving needs to be. In the employment space, for example, sometimes a performance issue can indicate some deeper structural or management problem. The key is in understanding what our clients do. We can offer a range of solutions and suggest things perhaps that they may not have considered.
One of the things multi-state employers struggle with is the rapid change of law in California and around the country. How do you advise clients on that?
There are a number of states that are vying at least for second place there, New York notably among them, and others. And that presents really two challenges. First, keeping up with current compliance requirements is number one within the jurisdiction. Many employers or organizations that cross state lines, that are in multiple states, and so reconciling differences that may emerge and may emerge quickly between California uniquely and other states is yet another challenge, requiring a lot of decision making. Having good counsel handy at the ready, responsive, and solution-oriented is very valuable.
What are you seeing coming down the pike, and how do you prepare your clients to navigate those changes?
Well, in California, in terms of what's coming down the pike, it's a lot of everything. But there are, for example, changes this year coming up in 2026 that involve additional requirements in response to record requests, record-keeping requirements for large employers' pay equity data that gets reported to the state and how that's kept, and the job categories that it applies to, restrictions on contracts that require repayment of debts by employees, and many other things. It's basically not one thing in California, and there doesn't tend to be a theme or a single focus. It's a lot of stuff going on a lot of the time.
Everything, everywhere, all at once.
Absolutely. Well said.
When clients come to you with a problem that you just don't think can be solved, what do you say to them?
In my 3 decades plus of practice, I have yet to encounter a truly intractable or impossible problem. There are certainly very difficult problems, but none yet, anyway, has presented as a true Gordian knot. Oftentimes, the more difficult the problem is, the more it will require a roll-up-the-sleeves approach, get to work on that problem, and find the creative solution for it. But when I have a client that tells me a problem is impossible, it'll be the one time I deviate from the customer is always right. I don't think and I don't believe in impossible problems.
Thank you, Jonathan, and thank you very much for watching. I'm George Whipple.